We're calling the meeting to order. Thank you. So, pursuant to the order of reference of Wednesday, May 5th, 2010, Bill C-471, an act respecting the implementation of the recommendations of the Pay Equity Task Force and amending other acts and consequences. And today we have a number of witnesses. We have the Equal Pay Coalition of Ontario, Mary Cornish. We have Communications, Energy and Papers Union Worker of Canada, Giselle Pajot. We have the Federally Regulated Employers Transportation and Communications, FETCO, and that's John Farrell and Barb Gagny. And we have Opus Mundi Canada, and that's Paul Derber, Senior Consultant, and Statistics Canada, Marie Drolette and Sylvie Michaud. So again, you'll have 5 minutes for your presentations, and then we'll be going into questions and answers. And I believe most of you have been here before, so you're familiar with our routine. So if we could start, we will start with the Equal Pay Coalition of Ontario. Thank you.
Thank you very much for inviting me. I am also in my capacity a human rights expert, and I want to focus in my short time, and there's a presentation which I think will be translated but is currently just in English that's written. Pay equity internationally is an international standard which is actually one of the oldest labor and human rights standards in the world. And increasingly under those standards, of which Canada is ratified, they require proactive implementation by employers, and they require state governments to take actions to ensure that human right is protected. And my research report for the task force went through how those domestic and international obligations require that kind of proactive report. The task force, which this act is asking to be implemented, and in fact said that the Canadian Human Rights Act provisions, which at that point covered both the public and private sector, needed to be amended to reflect that kind of proactive approach. And to ensure that, in fact, there was an expansion of coverage, to ensure that all kinds of different kinds of employees were covered, particularly because of the nature of women's precarious work. So the flow of the task force recommendations was completely consistent with a whole number of different reports internationally dealing both with the important role the pay gap played internationally in eroding actually economic development and in eroding women's equality, and that and also talked about the importance of governments taking action. So what we have here, in contrast, is that instead of action being taken to implement that report, which was based on very extensive consultations, we now have a situation where the private sector federally is still covered by an ineffective CHRA process, and we have the public sector, the private sector federally, and we have the federal public service actually in somewhat of a limbo at the moment, because the PSECA is not yet in effect, but their rights under the Canadian Human Rights Act have been taken away. So that is the situation we currently face. And to give an idea of some of the contrasts between the recommendation of the task force and the requirements under PSECA. The recommendations of the task force was acknowledging that pay equity was a fundamental human right. And because of that, you then have to ensure that it can be implemented, and you have to ensure an accessible process. The PSECA provisions, in fact, say the opposite. They don't ensure that it's a fundamental human right, and in fact, they take that underpinning of the human rights notion and take it away from the Human Rights Act and place it essentially, first of all, in a budget restraint bill, which makes it clear that its main direction is, in fact, to reducing budgets, and secondly, put it in a labor relations statute, and a labor relations statute in which it's left to collective bargaining. And that was completely inconsistent both with what the recommendation of the task force was, which is that it should not be left to collective bargaining, and also inconsistent with international standards, which require access to a human rights mechanism. Secondly, the task force, as I say, talked about kind of expanding the notions of coverage, and in fact, PSECA erodes substantive pay equity entitlements. It actually reduces the pool of employees who would have access to the human rights law by actually redefining what is women's work, what kinds of establishments would be covered, and and also, but most importantly, introducing the concept of market and saying that market considerations will now be considered in how you value women's work, when pay equity laws, in fact, were there in order to address the market practices which had resulted in the systemic discrimination. The second aspect, so that's the substantive pay equity entitlements. The second part of it was that it actually, the task force recommendations were attempting to set up a more effective process of access, to make it more accessible, to have a specialized commission and a specialized enforcement machinery. Okay. Instead, we're now put off into this collective bargaining machinery. And the third part of it is that the Pay Equity Task Force talked about trying to ensure effective remedial protections. The PSECA statute, in fact, limits remedial protections by limiting retroactivity that can be paid by putting it into the collective bargaining scheme. So in summary, we would say that in terms of moving forward, that the Pay Equity Task Force Implementation Act is the one that is consistent with Canada's international obligations and with its domestic obligations. Thank you.
Thank you so much. And next we have Communications, Energy and Paper Workers, Giselle Peugeot.
Good morning, everybody. And I've prepared a statement so that I could stay within the 5 minutes. I think I'm 3 seconds over, so I hope you indulge me in my 3 seconds. The CEP appreciates the opportunity to appear before the Standing Committee and to comment on the proposed Bill 471. The CEP is one of Canada's largest private sector unions, representing about 120,000 workers in a wide range of occupations across Canada, including both private and the broader public. The CEP has a long-standing record of defending the human rights of its member, and we have a strong interest in pay equity matters. We were the first union to undertake joint union management pay equity initiatives in several of Canada's private and publicly owned telephone companies. Our telephone operators lived through a 15-year nightmare as a result of the inadequate legislation. The CEP fought hard to bring pay equity to 4,700 women, of which about 18% died before ever seeing any compensation. We support Bill 471, which will see the abolishment of the Public Sector Equitable Compensation Act, the long overdue implementation of the 2004 Pay Equity Task Force recommendation, and finally ensure that pay equity remains a human right for all women. Sex and gender-based pay inequity is a human rights issue. It is the result of systemic discrimination and societal perception of the value of work traditionally performed by women. Consequently, to consider pay equity a labour issue to be dealt with at the bargaining table is not only detrimental, but an inaccurate characterization of the nature of pay inequity. It is imperative that pay equity remains a human right issue and it not form part of collective bargaining scheme. There are a number of reasons why the characterization of pay equity as simply an aspect of labour or employment law should be avoided. Firstly, to characterize it as such undermines Canada's international commitment to human rights, including equal pay for work of equal value. In a labour context, human rights are paramount, and parties cannot legally contract out of human rights obligations. By forcing pay equity into collective bargaining process and out of the process of human rights would be to risk the bargaining away or erosion of whatever pay equity gains have been made for women. The rights of the disadvantaged groups and minorities should never be subject to the whims of the majority. Secondly, the inclusion of pay equity as an issue to be negotiated through collective bargaining is to ignore the systemic and encompassing nature of pay inequity. The systemic discrimination is reflected not just in the organization of workplaces, but also in the structure and the strength of the bargaining units and unions. Bargaining units that are predominantly female may invite the replication of patterns and perception or gender segregation and the undervaluing of work. This lends itself to an inherent, though sometimes unconscious, power imbalance at the bargaining table, thereby undermining the principles that pay equity attempts to promote. We advocate a proactive, comprehensive, and collaborative model of pay equity legislation for all workplaces. While the CEP believes that individuals should have a mechanism available to them whereby complaints can be initiated, we acknowledge that the complaint-based system alone cannot ensure pay equity compliance. This would include a positive duty on employers to review organizational wage structures and remedy gender-based biases, pay equity practices. Audits must be conducted throughout and consistently to ensure a seamless continuity of pay equity throughout the federal sphere. In addition, employers must be provided with realistic and tangible timelines for the implementation of equitable wages structures and payouts for past discriminatory practices. It is the view of the CEP that pay equity is not a one-time remedy, but rather pay equity in the workplace must be examined frequently. It should be said that union participation cannot be equated with union responsibility for a compensation perspective. From a compensation perspective, employers pay wages and are solely responsible for non-discriminatory compensation practices. The inherent power of imbalance within the employer-union relationship and the fact that ultimately employers hold the purse strings precludes union from liability for pay equity. As you are all aware, the Pay Equity Task Force has exhaustively studied this issue. Almost 200 people gave oral presentations. There were 60 written submissions from groups across the country. There were 5 roundtable discussions with multi-stakeholder groups. And the task force looked at proactive pay equity legislation in a number of jurisdictions in Canada to identify best practices. The CEP supports the task force recommendation. This government does not need to reinvent the wheel on this issue. It's time to put it to rest once and for all and do what's right and long overdue for the women of Canada. Thank you.
Thank you. And Mr. Farrell, are you doing the presentation for FEDCO?
Yes, I am. Thank you.
Thank you.
Thank you, Madam Chairman. My name is John Farrell. I'm the Executive Director of Federally Regulated Employers, Transportation and Communications. And joining me today as an advisor on pay equity matters is Ms. Barbara Gagne, Manager of Labour Relations and Classification at NAV Canada, a FEDCO member. I've provided the clerk with a more full report of our point of view, which will be translated and be provided to the committee. And given time constraints, I'll refine my comments basically to those key matters that we believe are important to federally regulated employers with respect to Bill C-471. First of all, FEDCO unequivocally supports pay equity. The vast majority of FEDCO members are federal contractors and already comply with Section 11 of the Canada Human Rights Act and with other employment legislation, including the Canada Labour Code and the Employment Equity Act. The challenge is to devise and execute a fair and equitable plan that will achieve pay equity to the extent possible in an appropriate period of time. FEDCO did appear as a witness before this standing committee with respect to the Public Sector Equitable Compensation Act, and we gave evidence that we believe that certain aspects of this act were beneficial, primarily the fact that it requires both employers and unions to share the responsibility for equitable compensation. It also proposed, in our view, a more efficient, effective, and equitable problem-solving and dispute resolution procedure. Now, with respect to the recommendations of the Pay Equity Task Force, I wish to reiterate FEDCO's point of view, which was expressed in advance of the Pay Equity Task Force in 2004, and when we reported on the, we made comments on the report of the Pay Equity Task Force at that time. First and foremost, FEDCO supports proactive, problem-solving approach to pay equity. However, pay equity is an integral part in the determination of wages and other employment compensation in conjunction with many other factors which influence wages and compensation in a market-driven economy. The skill level, effort, responsibility, and working conditions required for a given career path affect wages. So does the supply of persons available in a given labor market and the demand for employees in a given labor market. The state of the company or the organization affects pay equity, and the state of the industry in which the company operates affects pay. The level of unionization of the workforce and the relative strength of the union and its ability to bargain for the bargaining unit and to negotiate wage and benefit increases also affects pay practices. The priorities of the workforce in terms of trade-offs involving wages, benefits, working conditions, work-life balance, and the duration of collective agreements affects pay practices. So therefore, a full understanding of all the aspects that affect compensation is required in order to develop a plan and redress any inequities that may exist. Persons assisting in the resolution of pay equity matters and the adjudication of pay equity disputes, in addition to an understanding of human rights matters, must also understand wage and benefit compensation, labor and employee relations, and business economics. Pay equity legislation must be simultaneously considered in conjunction with the Canada Labour Code. Both employers and unions must jointly be held accountable for achieving pay equity. This must be a bilateral responsibility, not a unilateral employer responsibility, as currently is the case. This is one of our major points. In unionized environment, it is the employer and the union acting together that make a bilateral agreement about what compensation is to be paid to employees. In fact, the union plays a major role in the distribution of the total compensation package. Both pay equity and collective bargaining are over the same activity, the level, structure, nature, and amount of compensation. And in unionized environments, these two activities must be integrated. The current process allows unions to negotiate an agreement and then file a complaint under Section 11 of the Human Rights Act and claim that it has been violated. The end result is that there are additional wage adjustments. In effect, the unions are using pay equity as a means to double dip. This means that pay equity is one of the principal reasons, this is one of the principal reasons why pay equity complaints have been protracted and contentious, and this double dipping must stop. Another very important element in the ability...
Wrap it up, please.
Pardon me?
If you could start to wrap it up.
Another very important point in the ability to manage pay equity is the determination of the term establishment or pay equity unit. We believe that the most appropriate unit for determining pay equity is the bargaining unit as determined in the certification under the Canada Labour Code. Employers, of course, do not unilaterally set wages, benefits, and working conditions for the unionized employees. So, thus, each collective agreement constitutes an appropriate pay equity bargaining unit. FEWO believes that this is how it should remain. Pardon
Thank
me.
you. Thank you. And next we have Mr. Derber from Opus Mundi, Canada. Go ahead.
Thank you, Madam Chair. And thank you for the opportunity to come and speak with you this morning. I want to essentially provide views on the shortcomings of both current pieces of legislation, that is the Public Sector Equitable Compensation Act, as well as the Canadian Human Rights Act, neither of which I believe actually achieve pay equity, in spite of what Mary Cornish has said to you about our international obligations, and one might add the Charter. It is my view that the PASICA, despite its title, in fact somewhat Orwellian, and its preamble espousing the principle of equal pay for equal work, in fact eliminates pay equity from the public sector through such provisions as not enabling comparison between the pay and work of men and the pay and work of women, as I was able to do as Director of Pay Equity, to oversee as Director of Pay Equity at the Canadian Human Rights Commission. The CHRA, in contrast, is complaint-driven, and that does not give reasonable effect to the principle of pay equity across the private sector. And as people have noted, there are really two standards now for pay equity. One for the public sector, which I believe is non-existent, and the other the private sector, which is the CHRA. The existence of these two legislative frameworks, in fact, give different rights to different groups of people, which in itself is inequitable. The examples of pay equity legislation on Ontario and Quebec show that a single proactive statute is workable, in much the way I think as you have just heard some of the principles espoused by FEWO. And it enables consistent treatment of women across a whole jurisdiction, which is the federal jurisdiction. My own advice to this committee would be that the PASICA be repealed and that a single proactive pay equity statute, such as recommended by the Pay Equity Task Force, be put in place. I have a number of problems, but which I won't go into a great deal of detail on in relation to the PASICA. I mentioned that pay equity comparisons are not enabled by that piece of legislation. If you look at it, you will find a definition of female predominant, which is pay equity speak for identifying where women work. If you had a pay equity piece of legislation, you would find something called male predominant. And there is no such definition. The principle then of pay equity is in fact abandoned. Despite the title, despite the preamble, despite the legislation saying that it believes in the principle of equal pay for equal work, work of equal value, I don't think that it's an effective piece of legislation to that end. A less fundamental flaw in the PASICA is the shift in the definition of female predominance. Under the Canadian Human Rights Act, we have a sliding scale when you try to decide the percentage needed to be female or male predominant. That's 55, 60, and 70. The new threshold is 70% under the PASICA, which is obviously higher for a number of groups. As a result, in the public service, for example, some 42,000 employees in female predominant groups lose any rights to pay equity. That is, they're no longer female predominant by virtue of that higher threshold. So there are some issues there, particularly since most of those groups you will find in the private sector, in the labor market as a whole, remain female predominant occupations. And there are a whole lot of other problems with the PASICA, such as lack of timelines, problems in actually bringing the parties to an actual agreement, which people, I think, around this table would probably agree with. So the problems with the CHRA are well documented by the Pay Equity Task Force. I won't go into them in any detail, except to echo what we heard from FEDCO, which is the complaints-driven legislation is not effective. Doesn't establish a level playing field, and I don't believe that this committee should continue to recommend that Section 11 be the predominant legislation for the private sector. So, in all, we lack effective pay equity legislation. Thank you.
Thank you. And we will now go to Statistics Canada. And Marie Drolet, are you going to be doing the presentation? Or?
Yeah. Alors, just first, je voudrais remercier le comité de nous avoir.
To thank the committee for inviting us to make this presentation to the committee on the situation. Statistics Canada is doing research on the gap, and you will all have a deck with you that will help with our discussion, and we just want to show you 6 slides, but we have additional slides, and you have any questions on the additional slides, we'll be pleased to answer those too.
To the bill, what we're here to tell you is present some of the different lenses that can be used to look at this issue of pay differential between genders. Marie.
Thank you, Sylvie. The fact that men continue to earn more than women is not new, and my goal here is not to provide a single definitive answer to what the pay gap is, but rather to present the different measures that are commonly used to describe pay differentials and to show that measurement and methodology do matter. If you'd like to turn to the first slide, please. The most commonly cited statistic on the gender pay gap is based on annual earnings. Here, women working full year, full-time, earn 72 cents for every dollar earned by men. And this is recent data from 2008 that is publicly available on CanSIM. An alternative measure is based on hourly wages. Here, we see that women on average earn 84 cents for every dollar earned by men. So why the large difference in the ratios? Well, a caveat of the earnings ratio is that it does not accurately account for differences in work volume. In 2007, full-time men worked on average 4 hours longer than full-time women. So you can have a gap in earnings simply because men and women work different number of hours. Another caveat of the earning ratio is that it excludes a significant portion of the workforce. Roughly 65% of women work full year, full-time, compared to 75% of men. The ratio based on hourly wages tends to overcome these two problems and have an added advantage of being job-specific, so it makes comparisons between men and women in their jobs much easier to do. If you'd like to turn to the next slide. Here we see the trends in the compensation ratio. And we have the earnings ratio is a consistent time series starting in 1976, and the wage ratio provides a consistent time series beginning in 1997. So between 1976 and 1992, we see that the earnings ratio increased by about 11 percentage points. And after 1992, the earnings ratio is roughly stagnant or constant. And this differs somewhat from the wage series. Beginning in 1997, we see that the wage ratio increased by 3.2 percentage points between 1997 and 2009. If you'd like to turn to the next slide, please. So what are the factors that explain the gap? In describing wage differences, researchers tend to look at the attributes men and women bring to the labor market. And this approach, that is assuming that wages are tied to the individual worker, is really due to the type of data that's available to researchers, that is large-scale household survey data. And that's what's dominated the empirical literature. So here we look at differences in work experience. We find that men, on average, have 4 years longer work experience than women. And this difference in work experience accounts for differences in work interruptions, restrictions on number of hours worked per week, or number of weeks worked per year. And because wages increase with experience, and coupled with the fact that men and women have a different amount of work experience, this explains about 11% of the wage gap. It's also a well-known fact that both men and women have been increasing their educational attainment in recent years. However, they still choose traditional disciplines. Since wages differ by the field of study, and men and women are in different disciplines, this accounts for about 4% of the wage gap. And the next bullet here looks at men and women belonging to different types of workplaces. And this is an analysis that comes from a linked employee-employer data set. And here we see that characteristics of the workplace explain more of the gender pay gap than the characteristics of the worker. So when we think about the wage ratio and we adjust for things that we think matter, like experience, education, and where men and women work, we see that on average, women earn about a little more than 90 cents for every dollar earned by men. Okay. I'd like to turn to the next slide.
So this will be time to wrap it up fairly quickly in order to be fair
So
to
despite this long list of factors that we include in these studies, a substantial portion of the pay gap cannot be explained by these factors. And there are numerous factors that we can't account for that could explain these pay differentials. And I'll just turn to the last slide. So my goal here was to highlight the fact that the gender wage inequality is complex. It requires analysis from a number of different perspectives, and to show you that measurement does matter. We went from an earnings ratio of 72 cents for every dollar earned by men to one based on a wage ratio, which is 80 cents, and then an adjusted ratio, which is closer to 90 cents.
Okay, thank you, and I'd like to thank all the witnesses. It's, I know, hard to put a very complicated subject into 5 minutes, but I'm sure with questions we'll get to elaborate much more on all the presentations. So we're going to start with a 7-minute round for both questions and answers, and Ms. Neville from the Liberals.
Thank you very much, Ms. McLeod, and thank you to all of you for coming out. Some of you have been here before, and we appreciate your coming back. Thank you. My first question is to Ms. Cornish. You made reference to international standards and the fact that, I wonder if you could elaborate on the international obligations and requirements.
Certainly. The original, actually when the UN was started way back with the Treaty of Nations back in 1917, it actually referred to equal pay at that point. That's why we say it's one of the first standards. The ILO Convention 100, which Canada ratified in 1972, is the main equal pay for work of equal value standard. And that standard is also part of what's called the core labor standards, which world governments, the UN, have all said are the basic standards that need to be implemented. In addition, the UN Covenant on Economic, Social and Cultural Rights also includes equal pay for work of equal value as one of the main contexts of that set of economic, social and cultural rights. The Beijing Declaration of the UN World Women's Conference, that's updated every 5 and 10 years by world governments, also includes equal pay for work of equal value.
Thank you. We've heard a lot about proactive legislation. The government says that the PSEC is proactive legislation. We're saying it's not proactive. I wonder how you would define proactive pay equity, and I would ask Ms. Cornish and anybody else who wants to answer that.
Proactive in terms of the obligations has been a requirement, first of all, that you implement equal pay for work of equal value, and so we say the PSECA doesn't do that. But most importantly, what it does is that it says that it is a requirement of employers to incorporate within their practices and have plans. They don't wait for complaints, which the old CHRA system does, but they have to promptly move to establish a proactive planning process which identifies the discrimination that exists in the workplace and sorts out how it will be eliminated. And that proactive part of it is, in fact, having a plan and having specific timelines in which you eliminate the gap. And we would say the PSECA doesn't do that.
Thank you. Go ahead.
Employers don't disagree with a proactive approach. In fact, we support it. In a nutshell, employers believe it's important to identify gaps where they exist, identify the reasons for the gaps, develop a plan to close the gap, understanding the gap, why the gap exists is most important, and also enlisting in a unionized environment the assistance of the union to work with the employer to achieve agreements and address issues that will close the gap. We cannot set wages in collective bargaining unilaterally. We are compelled to set wages and benefits in conjunction with the unions. So they have to share with us the responsibility to understand what needs to be accomplished and work with us to achieve it. This is really one of the main points that we wish to make
Then what I'm hearing from you, do I have time? Then what I'm hearing from you is that you are very strongly endorsing pay equity as part of the bargaining process rather than as a human right.
Pay equity is a human right, and pay equity is also part of the bargaining process. We can't change the labor laws that exist in this country. We have to operate within the confines of those laws. An employer cannot change the terms and working conditions of unionized employees without the involvement of the union, without fair collective bargaining, and without the give and take that is necessary to find solid solutions to complex problems. Pay is a very complex problem. Pay equity is certainly a complex problem to solve, but it's all part and parcel of a very difficult process of setting wages and benefits and compensation in the workplace. So we have to work to solve the pay gap and at the same time manage our businesses in accordance with compensation arrangements that make sense.
I want to hear from Ms. Pajot, but what I am hearing from you is that it's a human right that can be bargained. Ms. Pajot?
I totally disagree that pay equity as a human right cannot be bargained. You cannot bargain away human rights issue. That's a fundamental acceptance that you can't do that. Secondly, unions do not control the budgets of the employers. We have no control over the budgets of the employer. It is they hold the purse strings. If you want to see the success of a pay equity with proactive legislation, you should look at the Quebec model. And their pay equity is about 11 or 12 years old now. And they just finished about a year ago a study, an audit of their pay equity throughout the province. And it was very, very interesting to see some of the results. 82% of the employers said, I wouldn't do pay equity unless I was legislated to do it. But 100% of the employers in Quebec said, I did not close my doors because of pay equity. And so there was a collaboration between the unions and the employers, and that model worked really well because it was a proactive legislated model.
Do you have time?
To respond.
I'm sorry. Okay, I have another question.
So there's 30 seconds left.
Thank you. Very quickly, one of the features of most proactive legislation is that, in fact, it's separate legislation from the normal collective bargaining.
That's what I wanted.
And in my experience, it is extremely positive to get people around the table talking about the common goal of equity. Actually, even though there's some conflict, there's not the same dynamic at all as there is in collective bargaining. And it's a very positive exercise.
Thank you.
Thank you. And it's now Madame Demers.
Thank you very much for being here today. My first question is for you, Ms. Michaud. Thank you for being here. I'd like to thank you for all the work you're doing at StatsCan. And I'd like to ask you why is the data so old? It goes back to 1997, and I think that things have changed a great deal since 1997 regarding women's education, among other things. So I'm not sure whether this data reflect the same graphic image of women in the workforce. Things have changed since 1997. It's very old. I think quite a few things have changed regarding the schooling of women. I'd like to know, Ms. Bajot, if you fear that there will be any kind of fallout if we don't get this bill adopted very quickly, supposing there's a prorogation of Parliament FEWO before we could have the bill adopted. C-471, and it should be implemented in January as it was planned for public sector employees. It was supposed to be enforced. So what would be the repercussions, the fallout, the impact? Thank you. Well, all the data doesn't go all the way back to 1997. If you look at the first slides, the various tendencies, the trends go up to 2008. And some of the trends, some of the models, some of the sophisticated models are based on various factors, and that goes back to 1997. And we have another study that should come out. It's almost finished, and we should have more up-to-date results, and we'll be pleased to send them to you when our results get updated. Ms. Pajot, thank you. The consequences are very clear in my mind. How many years have been waiting for these statutes, and if all this comes to nothing within a few months, women will not have wage equity on the federal level. They'll have two different levels or groups of persons considered for wage equity, and you have taken it off the list of human rights. I can't imagine anything worse than that. So these are huge consequences. Women will be bereft of any defense because their union will be punished if they ever try to support a complaint, as you know. And then to try to see clearly into this, when it comes time to pay the wages, I don't understand the reasons for this. As I said already, the unions don't hold the purse strings. They don't direct the company. So we have to separate negotiations for wage fairness from the other negotiations. Well, why do you think that some employers are still confounding equity and equality in wages? Some employers are still confusing fair wages and equal wages. Mr. Turbeck. Really, the first basic principle for equal wages is much simpler. We compare the kind of work that is done, and that is nearly identical. However, fair wages are based on a comparison of value, of the value done by the work. And it is rather complicated, and we can compare all the work done by women instead of simply taking specific, very simple duties or very simplistic, for example, someone who does cleaning in a building, or someone else who does something that is very comparable. It's a much broader. How come the Treasury Board can confuse the fact that, or could believe that this new legislation replaces the new complaints-based regime with a proactive approach, and now the federal system resembles that of many provinces whose systems require proactivity. And what Ms. Laurendeau told us, this practice is supported by most specialists in the field. So how do you think that the government, through the voice of Ms. Laurendeau, could actually believe that? So very briefly, the federal at this time cannot accomplish equal pay or fair pay. By statutes, it's impossible at this time.
Okay, we'll go on to Ms. Brown, please.
Thank you, Madam Chair. I have a lot of questions. I'm not likely to get them all in 7 minutes. Just want to first of all address a question to Statistics Canada. We talked about the factors explaining the gap in wages, and I'm wondering, is this going to change exponentially now as we see more and more women going into higher paying professions, technology professions, medical, any of those?
But I'm not sure exponentially, but we do have some evidence that the wage gap is narrowing, and we need controls for occupation, industry, but the work experience is important too.
And I ask that specifically because we know that there are more and more women going into medical school, for instance. More than 50% of the registrants in our medical schools in Canada are now female. So that is going to change very quickly, that wage gap that we have traditionally seen. And if I could use as an example, if we have a young female lawyer who's working in an accounting office, and we have a male accountant working in a legal office, we're not going to have the same wages paid to either of those people who are not working in the discipline, because that's not the core business. If it's a lawyer working in an accounting office, the core business is accounting, and they're going after accounting clients. They need legal advice. In the same way, if you have an accountant working in a legal office, that person is not likely to be making the same wage as somebody working in an accounting office, because the law office is going after legal work. They need accounting services. You see what I'm saying there? Okay, now, thank you. I want to move to Mr. Farrell, if I may. I guess one of the things that I've heard here today is that pay equity is a human right. But what I'm also hearing is that as a human right, it's only to be addressed if someone complains. I would suggest that safety of my person is a human right, but it is not only my right when I complain if somebody has assaulted me. Would you agree with that?
I'm not really sure I understand the context of your question.
Okay, well, I'm just trying to establish that pay equity is a human right. And so what I am looking at is what we heard on Tuesday from one of our witnesses was that they were going to use the economic downturn to drive up wages for women, which I'm not sure is beneficial in a market-driven economy. And I wonder if you could talk about what you're hearing from your association and your group of employers on PASICA and how this is going to affect the larger context of a market-driven economy.
Well, let me address a couple of issues. I hear this term all the time in these discussions that you cannot bargain away human rights. First of all, we employers understand and believe that pay equity is a fundamental human right. Mm-hmm. And what we're trying to sort out is the appropriate way to get there, the appropriate way to solve the wage gap in an environment in which we're required to operate. And it's not a perfect environment, it's a difficult environment. So what we really need to do is find a way to properly problem solve the pay equity issue. We're not disagreeing that it's a human right, and we're not disagreeing that the Human Rights Commission and the Human Rights Act have a very important role to play. But what we're saying in particular is one of the things that prevents us from getting from where we are today to closing the wage gap is a recognition that we have to work on these issues together with our unions and with our employees. And you just can't simply continue to bargain as usual and not have both sides to the bargaining table to find a way to work together to close the gap. There's going to have to be compromises that are made. You might have to, for example, if you have a fixed budget to deal with, slow the rate of increase for male-dominated jobs and accelerate the rate of increase for female-dominated jobs where there exists a gap. But both parties have to agree to that. And if the unions are saying, no, we're not prepared to find a way to deal with this budget that we must deal with in realistic terms, and if we're not prepared to understand the market conditions and the factors that go into pay, all we're saying is business as usual, and closing the gap, Mr. Employer, is your problem. We're never going to solve the problem. So, I mean, we don't disagree with proactive employment equity. But what we need to establish and what we want to find is an appropriate way to work with our unions on an ongoing basis, not just in collective bargaining, in a problem-solving way that will get us from where we are today to closing the gap in a meaningful way that makes sense in a market-driven economy.
So, do I have a minute? So when we hear from Ms. Pajot, am I saying that correctly, that it took Bell 15 years, and you said that some of the women never got compensation because they passed before they were ever able to see that. That's an unfair system, is it not? And so Mr.
years?
If it takes
Yeah,
15 years.
absolutely.
And so exactly what I was saying, that if we can move from a complaints-based system into something that is a proactive system, as Mr. Farrell has used that word, is it not better for women in the long run? And as Mr. Farrell said, this is it's a forward-facing piece of legislation. We are going to have the opportunity to have the discussion before someone brings the complaint to the table. And in the same way as I said earlier, I shouldn't have to complain if someone assaults me. My safety to my person is my human right. I shouldn't have to complain to someone, first of all, before it's recognized that my safety is a human right. So we're looking at establishing that in pay equity.
Okay, we need to go on now to Ms. Matheson.
Well, thank you, Madam Chair, and I actually would have liked to have heard the response to that, and I'll begin by saying, Ms. Pajot, have you a response to that?
Well, I mean, we need proactive legislation, which is what is being recommended in the task force recommendations. I urge all of you to really study that task force. It talks about the involvement of the union. It talks about the liability of the employer. I'm not quite sure I understand the relation between a criminal act and human rights, but I can't comment on that part. But maybe Mary has a comment or two on that.
Well, I think in terms of, if I can give this as an example, the CHRA was a complaint-based system in which essentially federal employers, and like the ones represented by Mr. Farrell, the federal government, were essentially pulled kicking and screaming to the commission, to the tribunal. They weren't out there actually sorting out and being in favor of pay equity and doing their thing by themselves. They had to be pulled kicking and screaming. It took 15 years. Bell Canada went back and forth to the court. So that's what employers do when nobody's telling them they have to do it. They don't do it, unless actually it was unions who brought the complaints and who had the resources to bring the complaints to keep their feet to the fire over that period of time. But that isn't an effective system, and we all recognize that. So the issue is that in my view, what the government is saying now, because at the moment nothing is happening. The government has taken away the rights of women under CHRA. It hasn't implemented PSECA. Nothing is happening now. And when nothing happens, the employers continue to pay discriminatory wages. So another example of this is and that's another part to this issue of the pay gap. The pay equity laws only deal with part of the pay gap, right? They deal with the part of the pay gap that relates to the undervaluation of women's work. As Madame Drolet has said, the pay gap has a series of causes, and other parts of its cause may be discriminatory, and some may not, right? But the discriminatory parts can also be addressed by employment equity laws, in which women have not had access or there are barriers to accessing higher paying work, right? In Ontario, when the Employment Equity Act was repealed, they were supposed to also engage in a proactive planning process. They were to sit down with their employees and start doing that. The minute it was repealed, everybody stopped. They disbanded all the committees. Employers did nothing. So that's what happens when you don't have a law which says you will do it, and you will do it as a separate process. You'll focus on it, and this is your time frame for doing it. The problem with putting it into collective bargaining is that when you get into collective bargaining, what's going to happen under PSECA is that there's two remedies under the public service when you can't reach an agreement. You either go out on strike, so the women have to go out on strike to get a human right, which you're not supposed to do. You don't have to go, you shouldn't be giving up other requests like a safe workplace or whatever in order to get your human right, right? And that's why you separate the process. You separate the process, so you're not giving up something to get your human right. And the men don't say, well, I have to, which is essentially what Mr. Farrell's doing. The men will have to give up their pay increase in order for the women to have their human right, right? So So that's part of the problem. The second thing is if you're not in the stream in which you go and have chosen strike, then it goes to interest arbitration. If it goes to interest arbitration, PSECA says that the state of the economy, you can then decide whether you can afford to pay women the human right, right? So that's the other part of this process. International human rights standards don't allow you to say, can you afford to pay them? You are supposed to have established pay practices as an employer from the beginning. This is no revelation to employers federally that there's pay equity. They could have been sorting out these pay practices for the last 30 years, right? They don't need notice about it, right? They can be doing it. What they've done is not taken action unless they were taken by unions to the tribunal, and then that took forever. So to describe that as double dipping is really, it's just ridiculous. The unions spend enormous amounts of money trying to get compliance, right? So I think that's the context, and that's why people find that labeling PSECA as proactive is really, for anybody who knows anything about pay equity, is just a ludicrous notion.
Thank you. I think that sheds a great deal of light, and it helps in terms of, we heard in testimony that it's the employer who controls the hiring and who determines the workplace, and that employer could indeed determine that 70% threshold is never reached. So equating the power of the employer to the union is a spurious argument, in as much as the employer has control. Plus, you made reference to the fact that unions took employers kicking and screaming. Now, if they attempt to represent their workers, it's a $50,000 fine, which again sort of undercuts. I have another question. It seems to me that it's contradictory that the government that's setting the rules for federally regulated workers is also the same body who will be subjected to the rules. Does that not seem to be a rather contradictory situation, and how could it be resolved?
All right. It's one of the reasons, actually, in international standards that the standards require actually the government to set the example. They're to be the leaders, right? They're not to be the people who are falling behind. They're to be the leaders, right? And that's what's most upsetting, actually, that this is a budget bill, PSECA. PSECA was there to control the budget. And I think Mr. Farrell has quite candidly said employers want to control their budgets, right? So getting it into collective bargaining is this way in which they can try and control it, right? And then if you don't get what you want, you can strike. But the opposite is supposed to be the case, right? So from the point of view of the government, it's to take the lead, and it is under national and international obligations. It's supposed to ensure, and it's certainly supposed to ensure that its own employees, which is what it's doing here with PSECA, right? Because PSECA covers the people that it funds and employs.
Thank you. Thank you. So we are heading into our second round now, which is 5 minutes each, and we'll start with Ms. Simpson.
Thank you, Madam Chair. And I'd like to thank all the witnesses today. It's been extremely informative. All the other witnesses we've heard, and I think without exception, have said exactly what you did, that pay equity is a human right. And there's agreement that the PSECA is actually going backwards as opposed to going forwards. So if it's a human right and it shouldn't be bargained away, and based on what is stated in PSECA, when this is enacted, would it be fair to say that what we're doing is enshrining a violation of human rights here in this country in legislation? And I'd like each of you to quickly respond to that, if that would be a fair statement.
We wouldn't be commenting on that.
Mr. Gerber.
I think it's a backward step. I'm not a lawyer, so I can't say whether it is contrary to the Charter. I think that's a current challenge before the courts, actually. But it is, I think, an unfortunate step backwards There's no real requirement in that act, no mechanism in that act that I can see that will actually give effect to pay equity. And it's odd in a way that the preamble states unambiguously that the House agrees to the principle of equal pay for work of equal value.
Yeah.
And yet the legislation that follows is so Byzantine that most of us who read it think, my goodness, all those pages, it must be doing something.
Thank you, Mr. Derber. Ms. Cornish?
Well, I can give you my opinion that I think that it undermines and perpetuates systemic discrimination in pay in the federal public service. I think the failure to amend the CHRA, to provide, to keep the CHRA in place also means that the people covered by that, which are the private sector, federally regulated women, are also going to have their pay inequities perpetuated. The task force was an expert report which concluded that those women were not getting their pay equity. And remember that there are a lot of women affected by this proposed act who aren't unionized, right? And
Right.
for them, this is a whole other process that they need to deal with, and that they don't have a union to help them with.
Thank you.
Of course, it's going backwards, and I'm not going to repeat what my colleagues have said. My concern would be if we start saving money on the backs of women, where does it stop? What is next? And that's pretty frightening.
Thank you. Mr. Farrell?
Yes. We have said that there are certain aspects of this legislation, PASICA, which we think is beneficial. And the primary one, which could be applied in the federal jurisdiction for private sector employers, if it's discussed and managed properly, is the joint requirement of the unions and the companies to share responsibility to achieve pay equity.
Thank you. Mr. Lay, since you weren't able to comment on that question, I did have one for you, and it was based on a line of questioning that Ms. Brown had, which was, and you agreed that the wage gap it is narrowing. Ms. Brown stated that it should be narrowing fairly quickly now. Can you define quickly? Because I don't see this happening quickly. For instance, 10 years ago, you may not have that statistic. What was the wage gap, and how many inroads have we made?
I think we do have that statistic. Based on the 1997 LFS data, the gap in hourly wages, the ratio in hourly wages was about 81 cents, and it's increased by about 3 or 4 cents, so up to about 84, 85 cents.
And that's in 13 years, because
Yes.
you said 1997.
Yeah, sorry, the
Okay,
beginning
at
of
its current rate, are there any projections as to, especially based on legislation like this and moving backwards, how quickly we could expect to maybe reach some parity or something close to parity?
One issue that Ms. Brown raised was about the doctors, for example. We know that the wage gap is smaller among new graduates, and it tends to increase over time. The fact that we have a large influx of women in higher paid occupations, right now they're at low levels or entry-level positions because they're oh, sorry.
So we next go to Madame Boucher.
Bonjour tout le monde.
Good morning, everyone. I find very interesting all these things that you're telling us, and of course, obviously, wage equity is a basic human right. And here at Parliament, we are being paid the same amount for the same kind of work. And I have several questions because I come from a union background. And very often I put this question because I would like to be enlightened on this topic. Unions are there to defend persons. Up to this point, I'm right. But what I'm worried about is when the time comes for the female members to sit down like unions do with employers, to be absolutely sure that in the collective agreement women have the same rights and the same wages as the men. When I hear the testimony, it creates problems. I would like to know why, because I've never been unionized, so I'd like you to tell me, why is it so difficult to sit down with employers and say, well, this woman is doing the same job or more or less the same work as he is doing, and he gets $15 an hour, and she has a right to $15 an hour, and that will be signed black and white so that there's no double dipping. Could somebody please answer that?
We're waiting to answer. We'll start. Mr. Derber, I think, put his hand first, and then Mr. Farrell.
Je crois, Madame Boucher.
I think, Ms. Boucher, that there is a problem with the statutes governing collective bargaining, because every union has the right to negotiate on behalf of its members only. If this membership is only women, then the union cannot negotiate any comparisons outside of that bargaining unit. There is no comparison that can be made between this unit of women and the other units that are mainly men. So the wage equity should be facilitated by further legislation. There's a decision handed down by the Supreme Court in the Air Canada case, and another case that has been there for a long time, and you can get informed about it.
Yes, I'll defer to Ms. Gagne, who's with me.
We have proposed that we're for a proactive problem-solving approach, and the relationship between the unions and the employers does not only occur at the bargaining table once every 2-3 years, whatever the duration of your bargaining cycle. It's every day, and in order to determine relativity, there are many practices within an HR program that would allow the unions and the employer to work together, such as job evaluation plans that will allow you to evaluate jobs as they are created, as they are changed, bring together the parties to discuss the classification and therefore the ultimate compensation within the scheme outside of a bargaining process. So that we would advocate that you can have a positive relationship, you can bring people together, that it does not have to be an adversarial relationship, and it doesn't happen only at collective bargaining. Definitely when you get to the point of a collective bargaining cycle, you have to prepare, and that is when analysis and so on, it can be done and looked at in terms of determining whether there is a gender gap, and therefore what you have to do in terms of the wages going forward.
Okay. Monsieur Godet is next.
Merci, Madame.
Thank you, Madam Chair. Mr. Derber, earlier you didn't finish your answer on the current status on wage equity that Canada isn't ready. I didn't understand exactly. Earlier you said you hadn't finished your answer on wage equity. What is the current status in Canada and the current state of affairs? Canada cannot ensure wage equity. Oh, you mean between the federal and the provinces? Yes, I believe the problem is that our statutes do not facilitate wage equity in the private sector, given the fact that human rights do not require any action. You have to wait for complaints to come up. And I recently was party to a complaint where the Human Rights Commission refused to represent the case before court. And given the number of women involved, several dozen women, we had to drop it. We had to drop the case. And in the case of Air Canada, very likely there's no possibility of suing over this because the investigators don't have enough information about the work. The employers within the actual system are not obliged to provide data on the kind of work being done. Thus, we cannot make any kind of value judgment or any kind of estimation of the wage gap. But as you know very well, in Quebec, we have a system where both parties have to cooperate and come up with an agreement in good faith. Thank you. A question for Madame Toilette and Ms. Michaud. Is the statistics, so the new form will give you as much information as you used to have with the new census form? As long as we haven't investigated, we'll never know. We want the sampling of the new voluntary long form, and before seeing the results come in, we will not be able to judge of the impact. Ms. Pajot, you spoke of the risk and a good reason why we should abstain to make wage equity a simple object of legislation and job legislation. There's a good many reasons why we should abstain from making job equity a simple object of job or labor legislation. Well, you're speaking of the task force recommendations. If you look, if I understand your question, a new proactive act, the recommendations talk about proactive legislation for wage equity that should be adopted as soon as possible, and also that these laws be broadened in their scope to cover women, Aboriginal women and workers. And we hadn't mentioned that before, but also people with handicaps and disabilities. And all employees of the federal must be subject to the new legislation of wage equity, even those who are not unionized, as well as part-time, seasonal workers, temporary workers, occasional workers should be included. And these are the recommendations that the task force made, and they are very important for us to understand in this legislation. Do you believe that?
Oh, thank you, Madam Chair. I'm sorry. I must admit to a certain level of frustration because terms like equality and equity are bandied about, and there doesn't seem to be a real and clear understanding that equal pay for equal work is far, far different from equal pay for work of equal value. And I go back to the Bell example because I worked for Bell while I was going to school. And as a long-distance operator, I endured horrendous hours in terms of sometimes all night, certainly weekends. And it was known at that time that Bell employees, Bell operators were extremely well trained. The training was commensurate with craft, with the male workers at Bell. And yet the pay was far, far different. And when we start to look at the situation regarding doctors, we had female doctors come to this committee to talk about non-traditional work and the fact that because of the situation women face, their work was not valued in the same way as males. And it seems to me that that's what it comes down to, the devaluing of women's work. And while I know that that is entrenched, it seems to me that there is an obligation to pull us out of the previous century or even 2 centuries ago and say, women do important jobs and they must be recognized for the skills that they bring. And let's get rid of this market-driven thing, because that's driven down wages, not just for women but for men. It's a force that employers utilize over and over to drive down wages. And I want you to comment in terms of this devaluation of women's work and what we need to get into the 21st century.
The best case, I mean, to give you an example of how it's not just equal work for equal work. It's equal value. For instance, the most famous case is how we value zookeepers who take care of animals compared to women who take care of children. And the zookeepers have been found to be making about 30% more than what the daycare women are doing. And so in the Bell pay equity case, for instance, the operators, especially the 911 operators who were working under so much stress, were not being compensated to, for instance, a person that puts up poles in the woods and sets up some of the telephone lines. So it's about looking at what we do that is different and comparing the value of it. And, it's pretty disheartening that we're still not being able to grasp this. Pay equity is very complicated. I don't pretend to know everything about pay equity and how we come to it. But there's something very wrong when you have a zookeeper making a lot more money than a daycare worker who is in charge of our children, maybe one of our future leaders. It's very disheartening.
Mr. Derber.
Could I give another very simple example of why the old equal pay laws don't work? Under an equal pay law, by and large, you compared 2 jobs only to find out whether they were identical or not. So, for example, the cleaner who happens to be a lady, and I did work for the House of Commons for a while, so I know a little bit about the so-called cleaning women here. If they happened not to be having to carry a ladder, which the male workers might have to do, they couldn't be compared. So there were incredible restrictions, sound artificial, but you couldn't actually get at the work that was being done if there were any differences, practically whatever. Under the current international rules that Mary mentioned earlier of equal pay for work of equal value, we can look at all the aspects of the work. And that's important to give people, employees and employers, the notion that we're being fair. So underlying equal pay for work of equal value is the notion of fairness. We look at all aspects of the work, including stress, as you mentioned.
Okay, thank you. And we have Ms. Brown now.
Madam Chair, I want to go back to Stats Canada, if I may. I just want to follow up on that comment that you made about we have a lot of new doctors who are female coming into the workforce. Obviously, they're not making the same pay as somebody who might be 30 years experience. So if I go back and I take a look at your graph, it doesn't have a number on it. It just says proportion of population aged 25 to 54 working full-time. And I see in 1976, the population was 89% men and 37% women. And yet in 2009, we've got men at 78%, 78.8%, women at 62%. So that's going to explain a whole lot of how we got to closer and closer that the wage gap is being diminished. So as we move forward, and this is what I was getting to in my question earlier, about we see more and more women going into more technologically driven jobs. And I think of some of the jobs that are in the healthcare sector, for instance, where a lot of women are going into jobs in our hospitals now that are technologists who are very highly trained. And that in itself is going to, over the years, with the experience that they are garnering, bring that wage gap closer and closer, is it not?
The chart that you're referring to, the proportion of the population
right.
working full-time,
yes.
That's 89% of men that age work full-time. So we've seen a small decrease in the amount of proportion of men working full-time and a large increase in the number of women working full-time. That does not necessarily mean it's going to reflect in the gender wage gap because this is based on the number of people who are working.
Right. But as we see these women who are now in the workforce gaining experience, you made the comment about it being new doctors who are in the workplace. But as they gain experience, part of their wage is commensurate with the experience that they acquire, is it not?
Yes, it is. And we know that the wage gap in the health occupations is quite small. So over time, if it's already quite small, it's not really going to be a contributing factor to the narrowing wage gap.
But as we saw...
As a whole, because these are aggregate numbers, they're based on averages. Of course, there's a distribution around every average. So this is just very high-level analysis. I think what you're really interested in is very specific occupation-to-occupation comparisons, which is not part of what I've presented today.
But as we saw that over 13 years, you made the comment that we have narrowed the gap by 3% in 13 years. And so my contention would be that as we see women grow in their experience, and I worked as a draftsman in an engineering office, I was paid equivalent to what an entry-level male draftsman would be making. But I was not making the same wage as the design draftsman who was at the desk next to me, who had 25 years experience over me. My expectation, had I stayed in that career, is that my experience and years of involvement in that craft would have narrowed that gap very quickly because I had education that he didn't have. And I see that as a real proponent for us as females moving forward in the workforce.
See, I think that's why it's important to adjust these wage gaps for things like education and work experience so that you're comparing people more equally on a more
But that is
footing.
happening as we see equal work for equal pay. As a draftsman, an entry-level draftsman being paid equal to what a male draftsman would be paid, there was no wage gap.
Well, we know that the wage gap is smaller for new entrants into the labor market, whether it be by age or by experience, and that tends to grow over time with age just because women are more likely to have career interruptions, more likely to work part-year, part-time at various points in their lives.
Personal choice. Personal choice. And I give the rest of my time to Mr. Very well.
So there's 20 seconds left. There's two other people that wanted to do a 20-second response.
But can I just add?
Oh. We'll let Mr. Derber do a quick 10 seconds now, and then...
Real fast. Page 97 of the task force report will give you very interesting information on relative disadvantages to women in terms of additional experience. I think that might be very interesting, this whole table there.
Okay, so we will have time now for a 3-minute round, which means quick 3 minutes questions and answers, and then we will have to deal with a motion after that. So we'll start our 3-minute round with Ms. Ratanzi.
Thank you very much. My question would be to you, Mr. Derber, because you've been a consultant with the pay equity in the public sector. And I was a little confused about questions being posed, because in my understanding, pay equity means you're paid equally for the work that you do, whether you're a junior draftsman, senior draftsman. If I'm a partner in a law firm, I make equal to another male partner. So that's the premise. It doesn't mean whether you're at the entry level or the top level, that all will always be a difference, but everyone in a profession. So my question is, in the public sector, how many visible minorities are there? Do you have any idea? And we understand, so let me finish, we understand that visible minorities are always paid less than whatever. So could you just comment on that?
Well, I can't give you the statistics, although certainly the Treasury Board puts out annual reports on that. I can say that there is a comment in the task force report on the issue of visible minorities and the pay differentials that are found, as you say. That has not been part of the Canadian Human Rights Act directly, but it can be gotten at indirectly by doing systemic analysis. Very much more complicated than pay equity.
And that's fine. And when we talk about human rights, I mean, I think there was a response on the Status of Women report on pay equity 2004. And I think it was a very good report, because basically it balances out that pay equity is separate from bargaining rights, because they are two separate issues. Bill C-471 deals with those issues. I'd like you to comment on how that would help or enhance equality amongst genders and equality amongst different Canadians.
Well, as Ms. Bajot mentioned, the task force report also includes comments on Aboriginals, visible minorities, disabled, and so forth. So I think that in that respect, Bill C-47, by its reference to the task force report, has a broader ambit than Section 11 of the Canadian Human Rights Act, and absolutely broader than the PASICA has, which covers essentially gender.
So you were in favor of eliminating PASICA, and
Yes.
Ms. Cornish, I have one question for you. You were talking about the legislation, the pay equity legislation in Ontario. Were you talking about? Why did it get eliminated? Because that was a very progressive move.
Oh, no, I was talking about the employment equity legislation was eliminated in 1995, and that had a proactive mechanism for looking at the kind of barriers that you're talking about. The Pay Equity Act remains in place.
Oh, 1995, thanks.
Thanks. Okay, Ms. Burrow.
Thank you, Madam Chair, and thank you to the witnesses for taking out your time and coming, and certainly all of us do appreciate your time and your presentations. As you know, my time is limited. I've just got 3 minutes and a very short question for Statistics Canada. The hourly wage gap, is larger in non-unionized jobs than in unionized jobs. Could you please explain the difference?
I think the unionized wage ratio is upwards of 90 cents without adjusting for anything. Mm-hmm. And in a non-unionized sector, I think it's just below the 78 or 80 cents. I mean, one factor is that unions are more likely to have pay structures that are public, and that could explain why the wage gap within unionized sectors is smaller.
Okay, anyone else would like to answer the very same question?
Well, I think for some of the reasons the gap hasn't closed because there wasn't an effective mechanism in place under CHRA, because even in a complaint-based, unions are better able to use it. And a lot, certainly in Ontario even using the proactive law, unionization still remains one of the most effective ways to close the pay gap, even just by itself. Mm-hmm. Because generally when women are unionized, their wages rise and the pay gap closes. And it doesn't require them to go out and file a complaint.
The other thing with unionization is that we will represent the women and the workers and take it through the processes where non-unionized groups are working all by themselves.
Thank you, Madam Chair. That's all.
That's it.
Yeah, the rest of my time I would like to pass it to Ms. Boucher. Madam Carmen, do you have? That's fine.
Okay, so we have Madame Demers is next.
Merci, Madame la Présidente. J'aimerais, si vous le pouvez, Madame Drolet.
I'd like Ms. Drolet, if you could, to finish your answer to Ms. Brown. In the research that you did, were you able to determine that this was through personal choice?
I think what I referred to when I said that there was a remaining gap. We don't know what goes into that remaining gap. It could be a choice base that people choose certain occupations because they have a preference for the type of work or the type of responsibilities. On one hand. On the other hand, we don't know if it's some sort of expectations-based. If you think way back to your pre-labor market experiences, are you going into certain levels of education, major fields of study based on some sort of expectations based on gender? So that's a case in which your labor market behavior affects your pre-labor market behavior affects your outcomes, which are wages. So that unexplained portion, that portion of the wage gap that I went up to 90 cents. There's a lot of things that are going on. We may not have the appropriate skills that we measured that could account for some of the pay gap. It could be choice-based, it could be preference-based, it could be differential treatment by the employers against certain types of, for women, I guess. So there's a lot of things going into it. So to label that unexplained component as, a measure of labor market discrimination, there's a lot of things that you need to consider first before labeling it as such.
Merci beaucoup. Au cours des ans,
Thank you very much. Over the years, I think that Post-Canada has been going on for 43 years. Bell Canada went on for 22 years with the conflict. Could you give us an idea of how much money was spent on lawyers by the employer? Well, for the Bell cause, from our side, it cost about 4 to 5 million. And this was for a lawyer and an assistant, and for Bell, every day they had 7 lawyers attending the hearings, and if we had to pay 7 lawyers attending the hearings, I can hardly imagine how much Bell paid their lawyers and their consultants. So, human rights are not negotiable, but job or wage equity is. Well, I have a comment about women doctors. In May 2009, if you had a chance to look at the hearings that went on here, I was right here in this room, and there were 3 women doctors with 10 to 25 years of experience, and they said that they don't have wage equity either. We hadn't caught up with wage equity. And there was a very good discussion about the whys and wherefores. And instead of, if you go into professions like doctors and lawyers, the problems are still there. Thank you, Madam Chair.
Thank you. I want to go back to this discussion of choice, and I appreciate the answer from StatsCan, but it's been sort of framed that women earn less, there are pay gaps because they are in and out of the workplace, and that is by choice. I wonder if you could comment on that, because it seems to me that it may not be exclusively by choice. And certainly Ms. Cornish.
Well, I think there's the issue of the kind of structural and systemic discrimination women face in terms of their role in terms of reproduction are something that's being dealt with the entire world wide, and it affects, certainly in my experience, the fact that working women have children is one of the major pieces of discrimination that they face. And so that actually the women doctors who start off almost immediately have troubles if they decide to have children. So that's a whole other piece. And that's a piece that's actually addressed by employment equity laws that deal with trying to figure out how women and how employers can address the needs for women, which I would say is a societal choice that we have children and families, right? But that is separate and apart from the issue we face today. And that's the reason why this choice issue should not get mixed up in the issue of equal pay for work of equal value. Because equal pay for work of equal value has nothing to do with the choice of whether a woman got this job or that job. What it's about is saying the work women have, it's the work they're in, that's the job they've got. You evaluate that job. And the issue is that there's research that shows that the fact that women are associated with types of work has historically undervalued that work. So the technique of equal pay for work of equal value is using a mechanism of skill, effort, responsibility, and working conditions, the normal things employers use to value work, because job evaluation was actually an employer tool. Use that tool and compare that work, the work women's doing, not the work she might have got, could have got, or whatever, the work she's in, and see whether it's comparable to other male work in the workplace. And if it is, and it's comparable, what's the difference in pay, right? So it's a pretty specific technique, and the tool is to identify that discrimination where comparably valued work is paid less. And it's considered that it's paid less because you've done this analysis, you've sorted out the work's equal, and employers are paying them less. And we know that historically, if employers aren't required to redress the gap, they don't. Not only that, they actually don't do the analysis, right? And when you have a proactive pay equity law, it isn't that the union doesn't sit down with the employer, as Ms. Gagné is talking about. They do. I've been involved in these things for 20 years. You sit down, the union's there, the employer's there, you analyze the jobs, you see if there's a gap, and then the law says you have to close it.
Okay, thank you. And so that finishes our 3 rounds, and I'd like to thank all the witnesses. And you know, I have to say the commitment to pay equity in this very important issue, and really it becomes the deliberations whether 471 or Public Service Equitable Compensation Act is the best way to get there. But you know, please be assured that I think we all want to achieve pay equity, and it's really the debate is the best way to achieve. So thank you again. And I believe we now have a motion from Madame Demers that we'll be discussing.
Merci beaucoup. Merci.
Just suspend for 30 seconds just to I'm going to call the meeting back to order, and we had a motion from Madame Demers, and it came back to the table. It was to provide a little bit more information, so I don't think I need to read it. Could I ask perhaps Madame Demers to start the debate on your motion?
Oui, merci beaucoup, Madame la Présidente. Madame la Présidente,
Madam Chair, I would have really liked to have been able to see to add the demands of the other provinces, the claims of the other provinces to this, but once we looked through all of these claims, we saw that the only ones that were of the sort were those from Manitoba, but among them there were claims that I could not agree with. For instance, Manitoba, in its claims, wanted the Canadian government to decriminalize prostitution. I cannot agree with asking the Canadian government to decriminalize prostitution, so I couldn't include the Manitoba March of Women in my motion. I couldn't include their claims in my motion, but I could only include the claim for the World March of Women from Quebec, and there were 4 claims that were universal and were addressed to the Government of Canada and also to the United Nations. And these are universal claims. And these were claims that I could also endorse. So this is why I only included the claims from the March of Women in Quebec, because there were no other claims from the other provinces that had anything to do with Canada. The only ones were those from Manitoba, and I could read them out if you want, Madam Chair, and you'll see upon reading them that these were claims that were much broader. If you want, I can read them out, if you want.
I think everyone has them in front of them. Do we need them read out, or so? Is there any debate on this motion? Hearing no debate on the motion, I'm ready to call the question. All those in favor of the motion? Okay, all those opposed? Okay, the motion is defeated. Just a quick reminder that the members of the committee are asked to send to the clerk their proposed amendments by Friday, October 29th at 4 o'clock, and that's for Bill 471. And we will be discussing doing clause by clause on November 2nd. Motion to adjourn? Oh, sorry, to adjourn or?
Je peux avoir le résultat du vote, s'il vous plaît?
Results of the vote, please.
3 yes, 7 no.
J'ai pas compris. Merci.
Okay, motion to adjourn?